Hi, Jay.
Hi, Rashid.
How are you today?
I'm very well, thank you.
Before we begin, just some very quick housekeeping. Firstly, we're just having a conversation here. Any responses, any information provided is just information, does not constitute professional legal advice. Each case tends to vary. So if you have a legal query, this is for the audience, please obtain specific legal advice which is relevant to your individual circumstances. We've received a few questions beforehand, so we'll answer those as part of this. But if you have any questions, show up in the chat, so we'll take them on as we come across them. It's great to have you here today, Jay. Thank you for taking out the time. Would you like to kind of begin by introducing yourself a little bit to, the audience? We already know you.
Yeah, thank you very much for inviting me, first of all, and thank you for going through the insurance. So we're covered for not giving legal advice live on air. Very, very safe hands there. So my name's Jay. For those of you that haven't worked that out, I am an immigration barrister, and as Rashid has said in the leaflet, a deputy head of chambers at Imperium Chambers.
Again, fantastic to have you here. How long have you been in this space, Jay?
In terms of how long I've been in this space, so I've been working in immigration law since 2013, so good 11 years now, which makes
Nice.
me feel a little bit older than I did before. I started out initially as what, if anyone's in the legal field, and if any of our audience are lawyers, will know as a paralegal. Quite a common path now to becoming a barrister is to gain some sort of hands-on legal experience for you actually end up dealing with cases in court and taking on cases without any supervision. So I was a paralegal to a barrister who's done a lot to help my career, a man called Paul Turner, who's head of chambers at Imperium Chambers. In 2016, I then went on to become what's known as a pupil barrister. So the training part of being a barrister that takes place over the course of a year. And I fully started practicing as a fully fledged barrister in 2017. And a lot of that time has been spent doing immigration work. As I say, my paralegal work was predominantly immigration based.
Outside of immigration law, are there any other spaces you practice in as well?
Yes, so I am lucky enough to have what we at the law at the bar would call a mixed practice. A lot of my work is, as you say, public law, immigration law, where we're dealing with judicial reviews, appeals, or things along those lines. But besides that, my initial interest before I became a barrister and before I became a paralegal was towards the sort of corporate commercial side. So part of my day-to-day work as a barrister does involve providing advice to civil clients, attending civil courts and dealing with matters of that nature, and also employment as well. So I practice across the board. As a junior barrister, especially in the early years, I've done some work outside of those fields. I've done airline work where we've been taking airlines to court, family law work as well. So I've experience across a broad spectrum of areas of law.
Quite a varied practice then, yes.
Definitely a varied practice, yes. Never a day that's the same.
That sounds quite exciting. Is it like, is it a law something, did you always plan to be a lawyer? Is there a special reason you kind of found this calling?
I think there's a mix of reasons as to why I've ended up being a barrister and working in the legal profession. So as a child, surprisingly, I found a report from when I was in primary school where the only thing I wrote in that report as a student was I want to go to university and practice law. That then changed as time went on. I wanted to be a police officer. I wanted to work in that sort of field. Completely went away from it, wanting to be a pilot. And then, sort of, when it came to being a bit more serious about things and deciding which path I want to take, I've just met the right people. I've met friends at university who I started businesses with that were very strong, Usman Malik being one of those people who took me down the path of legal research. And one of the companies that we ran when I was doing my master's at University College of London was a legal research company. I then took some time to do legal work experience. As a barrister in particular, one of the things that you're recommended to do is something called a mini pupillage. Either 1 or 2 weeks is the normal sort of period. You go to different chambers, you spend a week with them, you get to understand how law works, what real life is about when you're a barrister, going to court, seeing clients and things along those lines. So I did 4 or 5 of those, and by the time I'd gotten to the end of that, I'd gone full circle back to primary school, realized that yes, law is what I want to do. But most of all, I quite enjoy what comes with the territory, the forensic analysis of evidence, trying to solve problems, and also just having a good old argument with someone that's a healthy argument and trying to reach a positive outcome for a client.
Course, now that makes sense. One of the things, whenever I meet a law student, I was like, what should I do? What kind of law should I practice? I strongly encourage, I'm like, why don't you go to a few minimum privileges or internships, just in the space. It'll give you kind of a flavor of what it's really like. It's very easy to romanticize the idea of a profession, without knowing, what the ins and outs, what it really looks like day to day. So just getting those mini privileges in, getting a few internships in really helps to align because you could be someone who really enjoys the law, but you need a particular kind of person to do it, especially do it over the longer term. So, whether you're that or not, I think that kind of experience, hands-on experience gives you that indication of we have we have let's pick up one of the questions. Yes, we got a few come in. This kind of leads lightly from the last one, which is what is a typical day in the life of a leading immigration barrister?
First of all, thank you to whoever's called me a leading immigration barrister. That's very generous. I don't think there is a typical day. And that's one of the beauties of doing the job that we do. It's very rare to have a day in the last 11 years that I've been working where I felt bored or where I felt I've been doing the same thing as I was the day before. Part of that is because, as you said, Rashid, at the beginning when you introduced me, every case is different. Every case has its own facts, and every day is different. You meet different judges and different opponents. On as part of my immigration work, that stems across predominantly the first tier tribunal, which is where most of the cases are heard. The upper tribunal, then, where we have the appeals and judicial reviews for most judicial reviews, and then high court work, and sometimes court of appeal if we're appealing decisions from lower courts. So that is part of the variation of the work that I do. Generally speaking, if we're looking at this from an Instagram perspective of follow me on a day as a barrister, I'm up by about 4 or 5 o'clock in the morning. I'm in chambers or at court by 6 or 7 o'clock. For anyone who's watching who wants to be a barrister, don't panic. Whilst early hours and long days are quite common, the reason I do that, I'm used to getting up early. I've done jobs in the past where I've been up early. I like to get to court, have a coffee, read the papers about the case, and just have a fairly relaxed morning as opposed to it being rushed. But not necessarily needed to be there so early. And generally speaking, if we're looking at a typical day, I'll get to court, I'll have my coffee, I'll read through the papers for the case. Most cases these days will start at 10 o'clock. They used to be splits when it was 10 or 2 o'clock. 9 o'clock, I'm usually meeting my clients for the day, talking them through what the court procedure is, getting to know a few of the gaps in cases and understanding what they're about. In addition to going to court, life as a barrister is also quite heavily paper based. A lot of my friends think, fantastic, you finish court at 11 o'clock that day. That means you've got the rest of the day to do nothing. It isn't really like that. As soon as I'm off of court, I'm doing one of three things on most days. I'm either reading the papers for the next day, drafting, which is legal written work that's either done to initiate a case or to take a case further if there's been an outcome that we're trying to challenge in another court, or I'm going through my emails and advising solicitors and also direct access clients in respect of all sorts of different cases. Just this week, I've done everything from two judicial review hearings. I've been advising in the context of company law for a director's disqualification case. The week before, I was doing a personal injury trial, in addition to doing all of the immigration work that I do on a day-to-day basis. So very much the message is there isn't a typical day. It's very varied. It's quite good fun. It is quite taxing, long hours, but generally speaking, there's a lot to do in a fairly short space of time.
Do the hours tend to get shorter as you spend more time at it?
In some respects, no. And that's a very good question. When I first started out, I remember preparing for a bail hearing and I spent 5 hours preparing for it. The hearing was going to last no more than 15 minutes. That 5 hours involved calling my then pupil supervisor, Paul Turner, to get him to provide me with advice, trying to remember everything I'd seen other barristers do, reading some self-help tools online, and really just trying to understand what bails were about, even though I had experience of watching them. By contrast now, an average bail hearing will take me no more than 15 minutes to prepare because you know what you're looking for. But that time that you've then freed up from preparing for that single hearing is now taken up by doing a lot more work. And quite often now, because I've been doing this for as long as I have, and I've got trust, a lot of my solicitors have been working with me for many, many years. I'm trusted with far more complicated cases, which do take a lot longer in terms of preparation, in terms of research. So, yes and no, I think is the answer to that. Yes, you become quicker at picking up what a particular case is about, what the issues are, and you don't have to spend as much time getting to grips with it, but then you become embroiled in more complicated work. And so time really does fly by.
That is true. So my next question kind of leads nicely from that, right? This is a good background for it. So we've, as we have a few law tech tools out in the market. So I cross paths with other founders in the space as well. And we've seen a few self-help tools come into the market, and that's particularly around housing law and employment law. More vanilla matters, nothing too complex. Just what are your thoughts around those in general? How do you reckon people find them or how effective they might be? We've had mixed reviews. Some people swear by them, some are like, it doesn't work for me.
I think the mixed reviews reflect what I'm going to say in my answer, which is they can be helpful in the sense that they can provide you with a guide as to what the law is. Sometimes, especially if you're looking at going to court, perhaps you're doing it by yourself, they can provide you with some comfort because you understand what happens, what the general position is, what the sort of makeup of a court hearing is. But what I would say to anyone who is faced with a legal problem, whether it's for yourself or friends or family, is to exercise some caution. There are some telltale signs to look out for. A lot of legal help tools or self-help tools that have been on the market may have been there for a number of years. Now, Rashid, as you know, the law changes faster than anyone can realistically keep up at times. If you're looking at a website or any sort of self-help tool that's outdated, you may be putting yourself into a dangerous position where looking at isn't reflective of what the law as it currently stands. Also, and again, going back to your initial introduction, there's only so far that a website or even a book can go to helping you because every case is different. So you may look at a case study. You may even speak to a friend who says, I've had a case that was similar to this. And quite often I get clients who come to me and they say, my friend had something very similar and this is what they did in that case to win. And the advice that we end up giving is completely different because what is quite important with law, pretty similar to when you go and see a doctor if you're not feeling well, is actually getting that tailored advice so that what you're getting is something that actually helps you and reflects your case. So look out for how old things are. If they're too old, they may be out of date. Also look out for where they come from. Are they from a reputable source? Are they from somewhere that you can trust to provide you with the information that you need? The difficulty with self-help tools is that there's a lot of them out there. Some are going to be more helpful than others, but it's a bit like Wikipedia. If you don't know who it is that's writing that content, you need to be all that bit more careful in terms of ensuring that what is provided is actually safe information to use. Nothing against them personally. I would say it's a good starting point, but you have to have your wits about you and appreciate whether this is something that can sensibly be used. If it's a complicated matter, if it's not, to use your terminology, a vanilla case, then really the self-help tool is nothing but a short guide as to where you need to go.
No, I agree. And I think that's kind of our thesis as well. So one of the things we found was when we were developing, our platform is like, should we have a product which is completely technical or should we have a product which is kind of a hybrid between, which essentially digitizes, or fast tracks the process of how, the law already should work. What we found was that in some particular fields, so this is medicine, so where you need a doctor, exactly your example, finance, so whether it's insurance, insurance might work, but maybe where it's financial advice, or in legal services, the cost of going wrong is so high, that it just doesn't make sense. Also, a lot of to use a self-help tool, you need to have a certain level of technical ability and a certain level of, just intellectual ability. Otherwise, the chances of going wrong with it are even further higher. And there's no insurance that covers, in that case. So yeah, I think that hit and miss, with self-help tools.
No, I totally agree. It's a question of, as I say, not just looking at the self-help tool as well, but you have to look at what is at stake. Quite often when you're going to court or you're in some sort of legal difficulty, you're either looking at losing money or having to pay money or something along those lines, or often something more important within the context of the immigration arena. It's being able to stay in this country, being able to bring loved ones over here, or being able to keep that family unity in place, keeping your job, keeping your entitlement to study in this country. It, there is always a risk with the self-help tools, as we've discussed, that things can go wrong. Once things go wrong, further down the line you are, the harder it becomes to fix. So quite often, my advice is get the advice of a lawyer very early on. Because if you start doing things yourselves, and I've had clients who've done things themselves, just to give one example, um, I had a gentleman who is, and obviously I can't give further details, but a gentleman who had three children to surrogate mothers in the United States. He has since been attempting to bring them over here, but in doing so, he's been making applications for entry clearance, and he'd been doing them himself. The applications were unsuccessful, and they're now at the appeal stage in the first tier tribunal. Without taking advice from a lawyer, what he then did was brought his children over here as visitors, but through Ireland. When that's gone to court, because he's done a little bit of digging online, and he's a fairly intelligent man. This is someone who runs a business and clearly knows how to go about life in general. He's now found himself in significant difficulty because the fact he's brought his children over here during the course of the appeal is something that is going to cost him in terms of the potentially cost him in terms of the outcome of that case. Something that needs to be considered is the damage that can be done and how difficult it then becomes to remedy it. So yes, of course, use the self-help tools, but think about the potential
Right.
implications as well.
No, absolutely. The next question we have essentially quite a simple one, I think, for yourself. It's there is a proposed increase in the international health surcharge, the IHS, which is supposed to go live, I think, 3 days ago,
Yeah.
and that's been delayed. Do we know to what date potentially? I know.
At the moment, the position is that it's been delayed at least till the end of this month, so the 31st of January. Uh, Realistically, I think debates are still going on around the draft bill, but it's likely to come into place at some point this year. Surprisingly, it doesn't coincide with the spring updates to the immigration world, on which they're increasing the amount of money that spouses need to show in order to bring their husbands or wives to this country or allow them to stay here, which is going up to 29,000. But at the moment, what we do know is it was due to, it was actually yesterday, the 16th of January, that the original bill had proposed that the immigration health surcharge would increase. That, as I say, cannot now be implemented at least until the 31st of January. My advice to anyone who is listening and has a looming expiry deadline insofar as their visa is concerned is, if you want to try and save yourself the money, one potential thing to think about is it worth applying slightly earlier so that you can be caught under the current rates? Because when they do go up, Rashid, they go up quite significantly. The current amount is £624 a year. Once these proposals, if and when they do come into play, that will go up to £1,035 for the majority of immigration categories. There's a slight difference for students, children, and those from the youth mobility visas. They go from 470 as the current figure to 776. But either way, the majority of people that are listening are likely to be facing the increase from 624 to 1,035, sorry. That's a 66% increase insofar as the overall position is concerned, all around about that figure. So my advice, think about whether you can save yourself a bit of money, because if you've got a family, sort of the average family, if I can put it in that way, of two adults, two children, 1,035 per year for four people is a fairly substantial amount of money. Um, there are, I should point out, and there has been, the immigration health surcharge was introduced back in April 2015 and has incrementally increased over time, nowhere near the figure that we are seeing about to come into play now. But there is the possibility, if there are people who are struggling financially, and of course with the cost of living crisis and the way things have gone, there will be people in that position where you can apply for a fee waiver to the Home Office. Now, the fee waiver has two strands to it. When you apply for an application for a visa, what you're effectively doing is you are paying the Home Office to process that application, and there's a whole variety of prices that they charge. And you're also then paying the immigration and health surcharge, which is designed to prop the NHS up. If those fees aren't affordable, unless you're applying for indefinite leave to remain or things along those lines, you can go down the route of applying for a fee waiver. It's important, again, as you said, seek legal advice as early as possible because you need to do things within certain deadlines. There's quite a lot of information that the Home Office asks for when you apply for a fee waiver in terms of making sure that your finances cannot meet those requirements. But there is that option for those people who are looking at that figure and thinking it may be outside of their budget to apply for either full fee waiver or also a partial one where they give you a discount as opposed to a full waiver of that fee.
Was now that's quite interesting. I'm sure people who have their backs kind of against the wall, something really to consider. My next question, is kind of is an interesting one. I think we get this a lot of the time. So what we found is, loads of people kind of been in kind of some form of legal challenge for an extended period of time. They become pseudo lawyers themselves, just because they'll go on to Google, research everything. What's and sometimes lawyers can be quite expensive. To be fair, everyone's ability is different as well. When should I? This is more general, but when should an individual decide to use a lawyer? It, essentially, what kind of legal matters are potentially matters, where which someone can kind of handle themselves?
I think without sort of giving a list, again, there's no right or wrong answer. A lot of that will depend on your own personal circumstances. And I mean this in uh, the nicest way possible. It will depend on your own abilities, your own intellect. Um, but also in terms of using a lawyer, I appreciate that generally lawyers are quite an expensive thing to be spending money on. There is, of course, the possibility of going to legal aid lawyers. Legal aid over the years has unfortunately become quite limited in its scope. So there's not much availability and certainly not the same as when I started practice or many years before that. But what I would recommend is the earlier you see a lawyer, the less chance there is of something going wrong. Even if you're confident, even if you can become a pseudo lawyer, or if you can search for something on Google, if you have that initial conference at the outset where you can see a conference is what we effectively, it's a consultation where you speak to a lawyer and you get that immigration advice or advice in any field. Getting that initial advice should give you an understanding of whether you need to continue using a lawyer. I see clients quite often. I work as a direct access barrister as well as working with solicitors. And sometimes I do say to clients, this isn't something I would recommend to use a lawyer for. You can go and do it yourself. That initial meeting will give you more information. You can then decide from that initial meeting, do I need further help? Can I go and do this myself? Is this something that does in fact require initial further information? As you discussed earlier, Rashid, and as you pointed out, one of the most important factors to think about, especially in the context of immigration law, is the risk that's involved with the application that you're doing. Over the course of the weekend, I was drafting a skeleton argument for an appeal for a client who really ended up in some considerable difficulty. He'd come to the UK as a student, this was back, I think, in 2008, 2009. He then applied to, I think he spent some time as a work and ultimately applied to become an entrepreneur. Now, the entrepreneur visa at the time was quite an expensive route. You had to have a £200,000 investment that you were putting into the UK into some sort of company. He did it himself. He looked through the immigration rules, he looked through the list of the documents, and he provided every single document except for one. The Home Office came back and they said, you meet almost all the requirements. You haven't provided a document from Company's House. Your application was refused. He reapplied, and as part of the reapplication, he submitted the document that was missing. And they came back and they said, you're an overstayer now because of your old application being refused. So even though you now have everything that you need and you would otherwise have gotten a visa, you're in this situation where you're here and we're not giving you one. Years went by going to see lawyers, getting judicial reviews, and ultimately in 2020, he managed to, I think 2021, he was successful in appealing a refusal of a human rights. But it's completely derailed his immigration journey. First of all, there was that gap. He lost a lot of money as a result of it. Business, unfortunately, wasn't able to survive and wait for him during that time. And he's broken his otherwise continuous residence that would have allowed him to get indefinite leave to remain. So that's really just an example of, yes, it's quite easy to look at the immigration rules at times and think, yeah, I can tick all of those boxes. One small mistake, and as you said, a mistake that you're not insured for, can have quite a serious impact, and one that went on for years in this particular case. So my recommendation is try as best you can see a lawyer as early as possible. Not everything that the law is about is very well publicized. So we've got the immigration rules and they change as quickly as these do. There are some things that get into the newspaper straight away. Rwanda is quite an exciting topic at the moment in terms of debate. The immigration health surcharge and the financial requirements, they made their way into the newspapers and the headlines because it was something that interested people. And then when the government made a U-turn, that was also something that interested the media. But the frequency at which the rules change, frequency at which the requirements change is shocking if you're not a lawyer and shocking if you are a lawyer. So you probably will not know if you're going down the right path or not.
No,
And
I sorry, go on.
sorry,
Yeah.
the other warning to give, and I'm sure we'll touch upon this in more detail, is not only can you lose a lot of money and your license, but minor mistakes can often lead to the Home Office accusing clients of being engaged in some form of detection because they've hidden information simply because they didn't realize they needed to provide it. When you go down that road, it becomes very difficult to get out of it. So again, it's just, I'm not scaremongering. It's just a warning really to remind people there are quite serious consequences, which is why a lawyer can be helpful.
No, I completely agree. It's Law Society commissioned a study, I think, earlier last year to the effect which said that in the people law space, so regular individuals like yourself and myself, 1 in 4 has had, for 1 in 4 adults has had a legal dispute over the past 4 years, and 50% contentious legal dispute over the past 4 years. So this is not necessarily vanilla cases, and only about 50% of the people access professional legal advice. So clearly, there's a big chunk of people, who are potentially, not accessing, justice or legal services where they should have or could. One of the things when we speak to people, and clearly we find that there's a commercial challenge there. We signpost people towards either citizens advice, there's something citizen advice covers, go speak to citizens advice, or towards, a legal clinic. They take long, but it's pro bono legal advice, usually accessible in about a week, 10 days time. So I think, absolutely people should do, but just something to be a space to be more prudent in.
One of the things I should just point out and completely agree with what you say, even lawyers take legal advice. Quite recently, I was speaking to a colleague of mine, a barrister, who specializes in property law, and he's advising one of my solicitors in relation to their own legal dispute because they've fallen into difficulty with the landlord of their offices. And they've done the right thing. They've realized that this is outside of their specialism. Just like you have a doctor, you have a consultant that deals with neurosurgery or something along those lines. Lawyers have their own specialisms. And so there's nothing wrong in needing help. And quite often people who are in the profession will seek help themselves.
No, I agree. Makes complete sense. The- My next question, is from one of the audience, and it's something you kind of touched upon, I think, earlier. And that's essentially, do we know what is going to happen for the uplift in the spousal financial support, from, I think, April this year? That's where the increase is supposed to go up from 18,600, I think, or 18,500 to 20,000, 26,000 something.
Yeah. So it's they've termed it a spring this year. It goes up. The current figure is 18,600, but then there are slightly more complicated figures to think about because 18,600 is the sort of minimum requirement that you need to demonstrate. The current position is that if you have children who aren't British, then that also goes up further. first child, I think it's just over £3,000. And then for every child thereafter, there's an additional income requirement that you have to show. On the 4th of December, and this made the headlines almost immediately, the Home Office said, we're increasing that to 38,700. And that was a monumental shift to go from 18,600, a figure that it's been for quite a long time, to 38,700 was seen as too high. So what then happened after that sort of outroar from the public and from various other individuals who were making noise about it is on the 21st of December, I think it was around that time, they came back and they said, what we're actually going to do is increase it to 29,000. But what the government then plans on doing is across the years is to incrementally increase that. So ultimately, we will end up at 38,700. The reason the government has said that's necessary is because times have moved on, the cost of living has gone up, and also essentially the income that people earn has gone up as well. There are going to be some changes around what I've said, though, because the current position, as I say, is that if you've got children who aren't British, the minimum income that you need to show increases. With the increased figures that the government is now putting into play, there won't be additional income requirements if you've got children. So it's going to be the £29,000. Equally, if I'm understanding this correctly, if you are currently on a family visa or you apply for a family visa before the increases come about, you will stay on the 18,600. So if you need to apply for an extension, you've already got a visa as under the 18,600 route, you'll be considered under that lower threshold. But yes, ultimately coming into force in spring this year, there is for those people it affects, there is another way of satisfying the financial requirements for the spouse or keep a spouse in this country. That is based on your savings. So if you don't have an income, you can rely on savings. And there's quite intricate rules around that that you'd need to think about the evidence that you provide and where those funds are coming from. Current figure is 62,500. That will increase to 88,500. In terms of the savings you need to show, they'll be going up by about 26,000.
Is it possible to show a combination of the two, or is it either?
Yes, it is possible to share a combination of the two. The Home Office has published guidance in respect of income. So it's not just that, you've also got self-employed income as well. A combination of the two is something that you can rely on, but it can become fairly complicated in terms of calculating what it is that you're able to take from your savings and what it is that you're able to take from your own income. For those people who are in the UK already and are applying for an extension or they're applying for their first potential spousal visa, if you're unable to meet the income requirement, the Home Office then goes on to consider what's called paragraph EX1 of the immigration law. Paragraph EX1 is a paragraph that questions whether there would be insurmountable obstacles to a relationship continuing abroad. And that's basically the fallback position. If you don't have enough income, that's the rule that the immigration team will consider. It is quite a high threshold. Insurmountable obstacles has been decided. The courts have looked at this in a number of cases and continue to do so. Can't be mere hardship. It can't just be standard impacts of being removed from the country. It has to be something more than that. So whilst it's a fallback position, it is quite rare that either the Home Office or if you end up going to court, an immigration judge would find that the insurmountable obstacles test has been made out.
Quite interesting, I think. Yeah, no, absolutely. Quite interesting. Next question we have is an adult British citizen settled here for about 2 decades at this point. He has a mother who is circa 62 years old and a father who is circa 70 years old living overseas, not British citizens. What's happening is they're growing older and, as they're growing older, their ability to look after themselves is diminishing. He's wondering if there's a pathway to move them here so he can better look after his parents closer to himself.
And I think a lot of British citizens who foreign origins or have parents in other countries do end up asking themselves at some point in their lives. The answer is yes, there is a pathway. but it is a particularly difficult pathway to quantify. It's called the adult dependent relative route. It's a route in which they will say something along the lines of, as a result of age, illness, or disability, the individual requires long-term personal care. So that's essentially care for their day-to-day living. Usually you're looking at things like taking medication, washing, dressing, cooking, and things along those lines. So if you've got parents who are abroad and who have health issues, as is unfortunately, especially uh, across the continent, can be quite a problem with certain illnesses, you tick that potential box. The difficulty isn't that. The difficulty is later on down the line, because what the rules also require you to show is that these individuals would be unable, even with financial help, to obtain care in the country that they're living in, either because it's not available or because no reasonable person can provide it, or it's not affordable. So that's effectively there are two strands. One is actually looking at personal circumstances around the health of the individual. The other is then looking at what care can be provided. Now, for anyone who works in the field and has been taught to deal with an adult dependent relative case, the Home Office will ask questions about close relatives in the country of origin. Some people will have close relatives, and becomes a case of then showing, if possible, that those close relatives are either unable or unwilling to provide the support that's required. But it unfortunately doesn't stop there, because they also require you to show that you can't have a living carer, a housekeeper, some form of home help, a nurse, anything along those lines. Now, the third element, which I haven't talked about yet, is that even if you can satisfy all of those things, first of all, the illness and the inability to provide, you also then have to show that if this person comes here, they will be adequately maintained, accommodated, and cared for without recourse to public funds, which means that they'll be given a visa if you're able to show that over the course of about 5 years, your parents are not going to become a burden on the public purse by having to go to the NHS, seeking benefits and things along those lines. It becomes quite tricky because, on the one hand, what you've got to do is demonstrate that you've got enough financial backing in the UK. So, in particular, if we take the example that he's got the money to support his mother and father, but at the same time, the rules are saying you've got to be able to show that you can't use financial support to provide help in the country of origin. So that paid help of having a carer, a housekeeper, or something along those lines. My experience, and also I've spoken to colleagues about this in the past, is that this is one of the most difficult requirements under the immigration law for me. I can think of very few examples. I was successful in one case for a lady who lived in Iran. She had quite a serious illness, which led to serious neurological condition. And the only medication that she was able to take and that she needed to take was only available in America. And because of the relationship between America and Iran, they were not willing to transport that medicine to Iran. So effectively, if she stayed there, she would have been without medication, and it would have had a severe impact on her health, probably leading to fatality. So a case like that, yes, it is desperate. My advice would be, if you are applying, because other cases will be successful, not every case has to be that extreme, think very carefully about the evidence that you need to provide. Quite often in a case like this, in addition to having lawyers involved, it's helpful to have medical expert evidence from people in that country. So if there are illnesses, if there are things that need to be addressed, you've got someone who can stand as an expert, provide a report to say, this is what mum needs, this is what dad's needs, and then also country expert reports and country background information to demonstrate whether or not that's actually available. And quite often, Rashid, what people end up doing is reaching out to care homes, reaching out to care providers to see if that care can be provided. I've had cases where we've been successful because the care homes have written back, whether it's by email or letter, saying, we understand the care that you need. That's not something that we're able to provide because we don't have the facilities. And that will be country and fact specific. So yes, it's possible to do it, there is a route for people in Filippo's position to consider, but it is one of the harder routes to satisfy. And in reality, it's going to be something where the evidence is really going to have to stack up.
Mhm. Feels like quite feels like the Home Office quite forensic as far as this is concerned, and something, to be quite to invest the time and resources and just kind of make sure that there's a robust enough case. I agree. No. So the next question we have is very, very specific. So what I'll do is I'll
I
just
think
kind
just before we move on, Rashid, sorry, I'm just seeing, just as we're at the end of that discussion, there is a follow-up question that someone's put in the chat. And that's really about, just to address that question, to deal with if someone isn't ill, but there is an intention to have some sort of a family unit in this country because people want to be close to each other, but they're not able to move back to their home country to be with their parents because they've got jobs, work, kids, etc. What's the position then? Unfortunately, the truth and the reality is that becomes even harder. The rules used to be quite flexible in allowing parents to come here, foreign parents of British citizens. That was changed quite some years ago when the adult dependent relative route was introduced. Now, current position under the law is that's the route you go down. Realistically speaking, if that's not something that you can satisfy, it's going to be extremely difficult to bring parents into this country. You're going to have to look at very compelling circumstances. The law effectively, and I sometimes feel bad when you repeat these things because when you repeat them to a human being, it can sound harsh. But the law effectively says that there's no choice as to where you live. You don't have the choice to start picking and choosing where you live if you don't have the right to live in this country. And insofar as not being able to be close to parents is concerned, I have every sympathy in the world for insofar as that those sort of situations are concerned. Separation from family can be extremely emotionally difficult. But if there isn't an illness involved, the situation becomes more difficult. What someone in that situation may want to think about is whether there's a better route, not a route that's going to give you the full on answer of long term presence in this country, but there is the visit visa option where parents, family members, and friends from other countries are able to come here for short term visits. But the idea behind the visit visa is that you come, you visit, and you leave. You're not supposed to use the visit visa route either as a way of getting into the country and then not leaving, or using it as a repeated way coming in and out so that you're making the UK your home. But unfortunately, the sort of response to that question is if there aren't illnesses involved and you don't meet the adult dependent route, we're in a slightly more difficult position.
of course, no. Uh, that makes sense. The next one we have is very specific, but I'm mindful of time as well. So I'll just kind of, just do a more general version of it for you.
Sure.
So there's essentially individual who's just been employed, individual in the UK currently on their post-study work visa, I think, who've received an offer of employment from a overseas company, which is sizable, turnover is like a 500 million, but they do not have a legal presence in the UK.
Right.
What I appreciate, the standard pathway would be you have a legal presence, you get a sponsor license, you sponsor them under,
Yeah.
one of the skilled routes. What options do these guys have available to them?
I think the only way that I can answer this question, because there's a lot more information that's needed in order for me to give a detailed answer. So I will emphasize what you said at the beginning. This cannot be legal advice, but realistically, I think you've hit the nail on the head. If you are, as an entity that's operating in this country, wish to have an employee who isn't British or who doesn't have a right to work through other routes, such as Appendix EU or indefinite leave to remain, you're going to need a sponsor license. Um, the sponsor license route is something that you can go down. There's then, Rashid, a number of different routes that you can explore. The global mobility route is one of them if the requirements under the rules are met in those circumstances. There are other options. The other options include representatives of an overseas business, but the idea behind that really with all of these expansion workers is that you're coming to the UK to expand that business. If the business already has a presence in this country, then the representative of an overseas business visa isn't the one that necessarily works. But yes, there are options that are available. But for that very particular niche question, I would want to see a lot more information about the job offer that's been provided, whether that falls within the particular form of employment, falls within the relevant codes, and what the best visa is, because you've got everything from global mobility, general skilled worker, healthcare, etc. But yes, possibilities are there. You can get a sponsor license for a company that has most of its operative presence outside of the UK. That's not necessarily an issue that you'd need to think about in a bit more detail.
Of course, no, that makes sense. And we will signpost them if they reach out to us again. We'll signpost them towards yourself so that they can obtain more specific legal advice. So one of the things you hear, and I think this is the final one, before we wrap up because we just almost at the hour. One of the things you hear is that, you put two barristers in a room, and never run out of stories to tell because that's just kind of what an interesting field it is. So before we go, what's like an interesting story or case, you've had, which you like to share with us and the audience?
I think what I'm going to do to answer that, Rashid, is probably tie it back to one of the earlier questions you asked about why it's recommended that you use a lawyer. Uh, Quite a lot of my career at bar, especially at the immigration bar, but also in some of the other work I do, is centered around allegations that are made against clients for the Home Office suggesting that they've been involved in some sort of dishonesty, some form of deception, or some form of fraud, quite often connected to the applications they're making to be in the UK or to come to the UK. And I'll give you a few examples because it shows the broad range of examples that apply. Most of the cases that I did a few years ago involved people who'd come to the UK to work. They were showing to the Home Office under what was known then as the Tier 1 general route, which is a certain amount of income that I have to earn. Here's the evidence that I earn it. And the Home Office would give them a visa. Years down the line, the Home Office started talking to HMRC and they started sharing their information. What HMRC showed the Home Office was that you've got Mr. X. Mr. X told you that he was earning £50,000, £100,000 as a self-employed person. And at the same time, they were telling us when they were doing their self-assessment tax returns, which we all love doing, that they were earning £3,000. There were massive differences. So the Home Office would then turn around and say, we've just discovered this information. We think you've lied to us. That's one example. Quite a lot of people that are listening and have experience in this field will probably remember one of the biggest sort of exposés that came about in 2014, which is when BBC Panorama published in February 2014 an article or a program where they'd gone undercover to English language test centres and exposed what they said was widespread fraud with people not taking the test themselves, but using other people to do it. And going back even further in time, the Home Office now comes back in a different scenario where they've got people who'd come to the UK from Albania. They'd claimed that they were from Kosovo because at the time there was the Kosovo and Yugoslavian civil war going on. And the Home Office, 20 or 30 years down the line, uncovers a piece of evidence by calling an embassy somewhere and says, you lied to us, so we're taking your British passport away from you. All of these cases for me have been quite interesting because it's allowed me to develop a niche sort of practice where uh, we're dealing with allegations of deception in quite a deep fashion. What all of those cases have always shown is one of two things, and this is something we've discussed off air before. There is always a better way of doing things. Quite often, and I understand that the sort of desire for applicants to come here, be careful of what you get drawn into. Can sometimes seem like there's an easy shortcut to doing things, but these scenarios, the people that I deal with now often have had indefinite leave to remain. They've had British passports. Years down the line, something is uncovered, which puts all of that into jeopardy because the Home Office is finding information that suggests that they may have been involved in dishonesty. But the first thing is, as much as the temptation can sometimes present itself, don't go down that route. The second thing is also, and this just comes as more general advice, it's become an unfortunate part of immigration law that there are quite a lot of scams around, and scams that you can become a victim to. And not only do you become a victim to those scams, but when the Home Office uncovers those, they sometimes paint you as being the perpetrator and the person who's been involved in that fraud. So, just one example that's quite relevant to present day. Quite a lot of individuals who are trying to come to the UK as tier two skilled workers, and as part of doing that, they'll be trying their best to find a job. They go to a third party. The third party charges them quite a substantial sum of money. And it turns out that the job that they're being offered doesn't exist. The sponsor license doesn't exist, or the certificate of sponsorship doesn't exist. My advice to anyone is, if you're in that position where you're applying for a job to come here, or you're applying for anything in reality, just try and do a bit of research. Find out if the people that you're working with are trustworthy. If you are using a third party and that third party is providing you with job offers, it is a good idea to contact the actual employer and see if they know anything about what's going on. Because if you do end up paying a lot of money and you end up in this situation, as I've been dealing with quite recently for a client who, yeah, paid upwards of £15,000 to try and get their life sorted, only to find out that it was all a scam. So the real advice with all of these things is as I say, I've developed a lot of experience of dealing with cases where people become the victims of dishonesty through other agents, or alternatively themselves become accused of having engaged in deception. And the advice is very simple. It's, first of all, be careful, make sure that you're checking, you're doing your due diligence, and also that you're keeping a paper trail of the information that you get. If you're working, you've got a paper trail of your income, of the work that you do, because it could be something that you have to face later on down the line that you're not expecting. I hope that provides a little bit of sort of guidance, just in terms of not scaremongering again, but just people keeping their wits about themselves when they're making these applications.
No, I agree absolutely. And just general prudence, it's just know, who you're dealing with. I think especially, more recently around the care sector, there's been quite a little bit of abuse. And not to say, those are the people, I assume the vast majority of the care workers we get, do a absolutely fantastic job and a part of the infrastructure we need to kind of run society, but there are bad actors in there. One of the things is, I think I could be wrong, in no circumstance should a sponsor, work sponsor, be charging applicants, fees to do a sponsorship. I think it's not permitted at all. Just being prudent, making sure, they do the requisite research. I think there's loads of material on the Home Office UK Gov website as well. You can check who's sponsor license, who has sponsor license, who does not. It makes sense to speak to them directly, understand what the role is like, and yes, no, not pay any sponsor license, any sponsors for sponsorship. Essentially, I'm sure Sorry, go on.
No, I just completely agreeing with you. Just two examples that I think come out to mind. So I'm currently representing a client through solicitors for judicial review, where the sponsor has lost or had its license suspended and revoked ultimately, because they, as a care provider, were issuing, I think, in the region of about 60 certificates of sponsorship within the space of a few months. And what the Home Office did was they went onto Companies House, they looked at the financial information that this company has filed. They said, hang on a minute, you've got to pay all of these people in order to satisfy their salaries, and you have assets less than £10,000. So that's one example. And the other one, just again, just to echo that due diligence point, quite a sad story of a client who's come over from abroad as a skilled worker. And the Home Office have allowed them to come over after having revoked the license of the sponsor, but not having notified this individual. And the reason the license was revoked was because the sponsor never applied for a license. Unfortunately, it was a case of some fairly in-depth fraud, where a third party had applied for a sponsor license for a company that knew nothing about it, and was then issuing certificates of sponsorship, trying to financially benefit in that way. So yeah, that advice that both of us have echoed: talk to the sponsor, do your due diligence, make sure the company that you're going to be working for knows you're coming, they've agreed to employ you and that everything is kosher. Because if not, unfortunately, once you're here, it becomes very difficult in terms of wanting to put things right, getting the money back, putting your life forward, especially if you've made quite a significant life decision of leaving the country that you were living in, hopefully selling houses, etc., to come and be here.
No, I completely agree. And it's also, the good employers, they want to have that open communication very early on. So, if you have an applicant who's, for example, scared of having that conversation, that's the opposite of what should be the case. You should know your employer, what kind of ethos they have, what they're looking for, what work over there would look like. And I have I have a few years of experience working with care providers, and we're discussing actually setting up some global mobility solutions with one right now, just in this space. It's most of them out. The third sector, the third sector care providers, there's quite nurturing, caring field. So you have to be a particular kind of person to be there. So most of them, they really value their employees. They really value the people they're bringing on board. So I'm sure, they will more than welcome having these conversations with candidates, applicants, anyone coming on very early on. So if, you any of those people, absolutely guys, please reach out, have those conversations with them.
No, absolutely.
I am mindful we're just on the hour. So time to wrap it up. Firstly, Jay, thank you so much for taking out the time. Thank you for your guidance.
Thank you for the invite. It's been a pleasure.
To the audience, thank you as well. Everyone, please have a good one. And I'm sure, we will speak to you again soon. Take care.